of 1954. Here, this particular act is almost similar to the Hindu Marriage Act, except for certain conditions. Here, one.
Come to this channel. So this.
This enactment has been specially made for providing for intercaste marriages. Here, normally, when a Hindu gets married to a Muslim or Hindu gets married to the Christianity, then there's pressures from the other side to get converted into Christianity or getting converted to the Mohammedanism. But this particular special marriage act has been specially provided to see that India has a casteless society where national integration is spread throughout, and there shall not be any caste barriers as far as marriages are concerned. And the object of this is to propagate what is called the to propagate nationality and to propagate intercaste marriages, and to see that the people who marry in intercaste are not castigated or they are not sent out to the community, and there is no compulsion as far as getting married outside the caste, and it is mostly meant for a casteless society. Here, as far as the Special Marriage Act is concerned, it consists of 42 sections, and almost it is similar to the Hindu Marriage Act, barring some changes. Here, first and foremost, is the section 1, which speaks about what is called the definitions part, section 2, sorry, sir. Section 2 deals with degrees of prohibited relationship. A man and any of the persons mentioned in part 1 of the first schedule, and a woman or any of the persons mentioned in part 2 of the said schedule are within the degrees of prohibited relationship. That is, as far as prohibited relationship is concerned, it is 3 degrees from the, it is 3 degrees.
Madam, unmute.
It is 3 degrees from the father's side and 5 degrees from the mother's side. That is, no relationship should be there within the prohibited relationship. That is one of the requirements. And second requirement is that a person should not have a spouse at the time of taking a marriage. And then these are the various conditions. That period of that is, it is said, what are the provisions which contains. The next one is it is said the charges with here the period of objective. That is, the question is the object of this particular enactment is to promote national integration, to promote equality among classes or the castes, religions, and there shall not be any compulsion as far as getting married outside the community. But experience has shown in India that when a person marries outside the community, still these caste barriers are existing in our country. And it is in the name of honor killing. What happens is when a girl marries outside the caste, the husband is murdered. But this is a very, very disturbing scenario which should be avoided at all costs. Here, the section 6 deals with the changes in the express provision, that is period of objective inquiry. Then divorce. Divorce is contained in section 8. The same grounds which are available in the Hindu Marriage Act, like mental cruelty, desertion, change of religion. Next, question 4 is when a person is guilty of rape and has been convicted, and when a person changes his religion and goes to another religion, or sixth one is he's suffering from leprosy, or he's suffering from communicable diseases, or he's suffering from what is called boots of insanity, or he's a person of unsound mind, or a person who has got a mental disorder, and the next most important thing is adultery also, when a person has illicit intimacy with another woman apart from the marriage. So these are the various grounds that are provided for divorce under the provisions of Section 8. Then the question is the Section 9, you can omit, please. Section 10 is alimony. Part of, please remember, this is a special provision in the Special Marriage Act. Even during the pendency of a divorce petition, partial, that is, the alimony can be granted in part. Of course, in Hindu Marriage Act, you don't have, but you've got a corresponding provision called Section 24 and the Hindu Marriage Act. But under the Special Marriage Act, under Section 12, Section 10, part of the amount can be granted as alimony. It is nothing but maintenance to keep the body and soul of the lady intact. And next one is the question is then offices and punish. Then suppose, let us say, anyone commits an offense under this particular act, he is punished and imprisonment is also imposed, and mostly 6 months imprisonment is imposed. Then the question is the what are the then section 12 or 13 deals with what is called judicial separation. What do you mean by judicial separation? Judicial separation means separation from bed and roof, where the marital ties are kept alive, and there is a time given for settling the disputes inter se, and so that they may come together and temporarily they stay in different houses. And please remember, the marriage is not broken, but the marriage is kept intact, and the marriage is so that conciliation may take place. And for that purpose, the question is judicial separation is provided. Then the why the provision for judicial separation is provided is, one is, what are the grounds? Polygamy. Polygamy means a person cannot take another wife during the subsistence of the earlier valid marriage. That is, polygamy means you cannot marry multiple wives. Then the person suffers from unsoundness of mind, or he has got what is called mental disorder, or he has got what is called the question is, it comes under the close proximity, that means prohibited relationship, or then. But one important thing in the Special Marriage Act is, if you want the marriage to be solemnized under the provisions of the Special Marriage Act, 30 days advance notice has to be given, and and the forms have to be filled up and submitted before the marriage officer, normally who is this sub registrar of that particular place, and then within 30 days objections will be called for. If anyone has got objections as far as the solemnization of the marriage is concerned, those objections will be heard and then disposed of. And if no objections are received, the marriage is registered as per the provisions of the Special Marriage Act. And then section 11 deals with declaration to be signed. So whatever declaration you give before the marriage officer, who is normally the sub registrar of that particular area, both the would be husband and would be wife have to sign a declaration that they don't have a spouse living to the first marriage, and that this is their first marriage, and each one is desirous of coming together in wedlock, and it has to be signed by both of them, and declaration has to be given to that effect, subject to notice of 30 days being given in advance, so that objections are called for, and once no objections are received, the marriage is solemnized. Then section 12 is the who is the authority to solemnize the marriage. Here under section 12, the authority is the marriage officer, that is the sub registrar of that particular place. And under section 13, a marriage certificate is issued by the sub registrar or the marriage officer in proof of marriage. Then, sir, 14, that is, yeah, I'm sorry, that is. Uh, 13 declaration. Well, marriage certificate. That's it. Then, as far as the religion part of it is concerned, there shall not be any objection. You may belong to different religions. There is no compulsion that you should get converted. And but if all the formalities have been complied with, then the marriage is, and 30 days notice is given and no objections are received, then the marriage is solemnized before the marriage officer, and the marriage officer issues the marriage certificate. Then Section 26 deals with validity of children. Suppose let's say the children are are bound by the what is called. Suppose let us say children are born out of the Special Marriage Act. These children get equal rights as in Hindu Marriage Act, and they also get equal share in the father's property or the mother's property. Then that is then procedure for registration is, as far as the procedure is concerned, it is section 16. It says both the husband and wife, along with the photographs, along with their proposed marriage, and along with the declaration that they do not have a spouse living through the first marriage, and that this is their first marriage, and they have no objection for getting into the wedlock under the Special Marriage Act and getting it registered, signed by both the parties and the prescribed form, and with the photographs, and also the consent of the parents of the respective boy and the girl. They have to be filed, and after scrutiny, the registration will be done. Then Section 17 provides for what is called appeals from orders. If any order is passed in a judicial proceeding, be it a judicial separation or be it a divorce, it is appealable to the High Court. Please remember, from the family court, an appeal lies to the High Court within 90 days. If it is a family court, if it is not a family court, if it is a district, no family court is available within 60 days. And what are the requirements for filing an appeal, sir? The requirements is you must file the appeal in the proper form, and also that is you must file it under section 17 of the SM Act, or what is called the Special Marriage Act of 1954. And if it's a family court, you have to file it within 90 days, and if it's any other court, it is 60 days. Then effect of registration. As far as registration, once the registration is done after proper scrutiny, after proper verification, after proper forms are filed, then in that case, it's a judicial notice, or it is a notice to the entire public at large, saying that these people have got into the wedlock and their marriage is duly registered. They are man and woman, they are husband and wife, and their marriage is just and proper. They get universal recognition. Then effect of number of what is called uh, effect of marriage on member of an undivided family. Suppose let us say you don't get married under the Hindu Marriage Act, but you get married under the Special Marriage Act. What about the law of succession? As far as the law of succession is concerned, they are treated as members of the undivided family, and whatever share they would have got had they got the marriage solemnized under the Hindu Marriage Act, but they get it done under the Special Marriage Act, their shares are not affected in any way. Then, sir, the section 20 deals with rights and liabilities not affected. What are the rights and liabilities not affected, sir? That means you continue to be a member of the family. You are not being castigated. You have not been driven out of the house. Your shares will be kept intact, and whatever liabilities are also there. As a member of that undivided family, it is your duty to discharge them. You cannot disown your liabilities. Just like you get your assets, the same way, as far as liabilities, as a member of that family, you are liable to discharge those debts. Then, as far as succession is concerned, Section 21 says, as laid down in an enactment called the Indian Succession Act, the succession follows. That is, the shares will be decided accordingly. And even though you are got married under the Special Marriage Act, your shares will not be affected in any manner. Then we go to what is called uh, Section 22. Section 22 deals with, yeah, what are the provision for restitution of conjugal rights under Hindu Marriage Act, sir? It is Section 9. But as far as the Special Marriage Act is concerned, it is 22. Restitution of conjugal rights. What do you mean by restitution of conjugal rights? It means either party who has left the company of his or her spouse, there is a process through which you can compel the opposite side to resume the marital life. And that process through which you compel the other side to resume the married life and come and live with you, it is called restitution of conjugal rights. What do you mean by conjugal rights? The conjugal rights means what duties you are supposed to perform as a husband and woman under the Shastras you are supposed to perform. You cannot forsake the company of your husband, or your husband cannot forsake your company. In that case, what happens is you can always file a petition if your marriage is solemnized under the provisions of the Special Marriage Act. Section 22 says a petition for restitution of conjugal rights is maintainable. So, what are the contents of the petition which you would file, sir? You would say that normal. Suppose just visualize that I am the lawfully wedded wife of the petitioner. I am a respondent having been married to him on so and so date at so and so place. The marriage was an arranged marriage, and the marriage is solemnized under the provisions of the Special Marriage Act 1954. Then next para you will say, sir, out of the said marriage, two children named so and so, age so and so, and another child age so and so were born to the petitioner through the respondent, and then the children are presently in the custody of the wife. And next para you say, sir, that the husband, that is the respondent, has left the company of the petitioner and living separately, and in spite of the best efforts of the petitioner to compel her husband to come and stay with her and resume their conjugal company, he has not done so. And subsequently, a legal notice was issued on my behalf to my husband, calling upon him to take me into his house and resume the married life. And the respondent, that is my husband, received the notice but did not send any reply, nor take me back to his fold. And hence, I have no other alternative than filing this petition for restitution of conjugal rights under the provisions of Section 22 of the Special Marriage Act. Then, as far as judicial separation is concerned, sir, it is dealt with by Section 23. What are the contents of a judicial separation, sir? I'm talking from the husband or wife part of it. I was married to the respondent on so and so date at so and so place, and the and the marriage was celebrated at so and so place, and a marriage was duly registered under the provisions of the Special Marriage Act 1954, and the marriage certificate is filed and marked as document number 1. Next paragraph, that the respondent, that is my husband, has treated me has inflicted mental cruelty on me and has subjected me to all sorts of harassment, physical and mental, and I have lost my complete peace of mind, and I apprehend danger to my life if I live with the respondent, and hence I have no other alternative than filing the present petition for judicial separation. Then, sir, one more next para is subsequently I issued a legal notice through my advocate dated so and so, calling upon the respondent to agree for judicial separation. The respondent received the notice but did not send any reply. Office copy of the notice and the acknowledgement are filed and marked so and so. Next para, cause of action for the petition arose on so and so date when the marriage between the parties was solemnized as per the Special Marriage Act at before the registrar marriage officer, whichever place it may be, and also on so and so date when the uh, legal notice was issued by the petitioner to the respondent, which was not responded to. Then next is this honorable court has jurisdiction to try this petition as the parties were married at so and so place within and the parties last resided together at so and so place, and this honorable court has got jurisdiction. Then court fee so and so, no suit has been filed. Then after that, you pay the court fee as a section. I think for Special Marriage Act is not 10 rupees, it is 25 rupees. Then the prayer clause. The petitioner, therefore, I therefore pray that this honorable court may be pleased to pass a judgment and decree for judicial separation, direct separating me from the company of the respondent through judicial separation, and cost be awarded. and whatever documents you file it accordingly. Then next one is section uh, legitimacy. Then you got what is called 24 and 25 deal with what is called void and voidable marriages. Void and voidable marriages. What do you mean by void marriage? Void marriage is when you get married within the prohibited relationship. Number two, when there is suppression and concealment of material facts. Three, when fraud has been played before entering into the marriage, or your consent has been taken by force, under coercion, undue influence, so on and so forth, or that the marriage is not properly solemnized, or let us say the husband is suffering from mental disability, mental disorder, or he is of unsound mind, or he is an idiot, and so on and so forth. What all grounds are available, the marriage is void. Now, that is, marriage has no effect at all, or it's a nullity. Then the next section, sir, what do you mean by voidable? Where the consent is not free, where the consent is not free, it is taken under compulsion, and then in that case, an option is given to you to avoid the marriage. And then when you decide to avoid the marriage, the provision is section 25 of the Act. Then, sir, next one is uh, legitimacy of children. That is, as far as children are concerned, they are all, even if they suppose the marriage is broken, either by judicial, either by voidness or by voidable, if any offsprings are there, they are deemed to be legitimate children and are entitled to what is called a right in the property of their father. That is what is called Section 26. Then Section 27, sir, it deals with divorce. The same grounds which are available to you, like what is called mental cruelty, desertion, change of religion. Fourth is having communicable diseases. Fifth one is you are guilty of polygamy. Sixth is you are guilty of bigamy. Seventh is when you are guilty of having sexual intercourse beyond the marriage, or when you have changed your religion or given up the religion to which you belong. All these grounds constitute the grounds which are available to you for divorce under the provisions of Section 27. Then, sir, 27A says, it says alternative relief. What do you mean by alternative relief? Suppose you ask for divorce. You can also say alternatively, if divorce cannot be granted for any reason, at least a decree may be granted for judicial separation, separating the husband and wife from the roof and the bed. So instead of divorce, suppose by any chance, like specific performance, you say, in case specific performance is not decreed for return of the money which has been paid as advance, in the same way, alternative relief also can be claimed under Section 27A. Then, sir, the most important section is 28. 30, in Hindu Marriage Act, you've got a provision called 13B, which talks about divorce by mutual consent. Both the husband and wife who feel that their marriage has ended in a disaster, and there is incompatibility, and there are frequent quarrels and differences between the husband and wife, they call it a day, and they enter into a pact whereby they can seek divorce by mutual consent. Both of them can jointly file a petition for asking the court to dissolve their marriage by mutual consent. And they also say there is no arrangement, there is no collusion between them in filing the petition, and they request the court to decree the OP for divorce on the ground of mutual consent. That's why they say Mia Bibi Raji hai to kya karega kazi. Court is absolutely helpless. Court tries its best to see that both come together. They arrange for conciliation meetings, they arrange for settlement, but even after that, they don't come together. The court has no other alternative than to dissolve the marriage by divorce by mutual consent. Then, as far as this is concerned, next one is uh, then, when the question of remarriage comes up, once a divorce is granted through mutual consent or through any of the provisions of this act, you have to wait for a period of 3 months. That is a period of appeal before you get remarried. No doubt, no one says you cannot get remarried, but you have to definitely wait till the appeal period is over. Then, sir, the question is remarriage of divorced persons. As far as the divorced persons are concerned, be it a man or be it a woman, they have to wait for the appeal period and then only get married. Then, sir, what are the contents you mentioned? I have already said. I think it is not new to you. You say when the marriage has taken place, how it has taken place, under which act it has been solemnized, where is the marriage certificate, then after marriage, where you and your husband started living, and then what was the attitude of the husband towards you, what are the acts of mental cruelty inflicted on you, what are the acts of desertion inflicted on you, what are the boots of insanity on the part of the husband, what are the mental disorders and how he has committed adultery, so on and so forth. Those grounds have to be narrated to maintain a petition for either judicial separation or for divorce. Then proceedings in camera. Please remember, for some people, watching a matrimonial proceeding may be a drama, maybe a television serial, maybe a cinema, but still, the persons who are really affected, they are the worst affected possible because their entire domestic story comes into the open. And that is the reason camera proceedings are held as far as matrimonial matters are concerned. And the court sometimes calls the husband and wife in the chambers and holds the proceedings, or in the open court they hold the proceedings and ask all the advocates to leave the court so that parties are free to depose what they wanted to say, what they wanted to testify. So normally all proceedings under the matrimonial proceedings are held in camera without the presence of anyone except the judge and the bench clerk perhaps and the respective advocates. Then, sir, the question is relief for then uh, next one is, as far as the limitation is concerned, any appeal that has to be filed before the Honorable High Court has to be filed within 90 days if it is from a family court and 60 days if it is from any other court. Then, sir, you have got a provision in the Hindu Marriage Act called Section 24. That is maintenance pendentility or legal expenses. The same provision is also provided in the Special Marriage Act. That is, it is said that it is for alimony pendentile permanent alimony. Under Section 36, interim maintenance can be granted during the pendency of the proceedings, and if the person is not able to foot the bill of the advocate, legal expenses also can be allowed, directing the husband to pay the money, and then alimony, that is pendentility, is paid during the pendency of the proceedings. But as far as the next section is concerned, a permanent alimony is fixed till such time the girl gets remarried. Alimony, please remember, unfortunately, the acts are made in such a way only the woman is entitled for maintenance. As far as the husband is concerned, no, he has to pay. That's all. The question is permanent alimony. After the decree is passed, the court itself fixes a permanent amount, a lump sum amount, which has to be paid by the husband to the wife towards permanent alimony till such a permanent alimony, and after that, the wife has no right to claim any amount from the husband. Then, next provision is Section 38, custody of children. Here, sometimes it so happens, sir, due to no fault of the children, when there are bickerings and quarrels and differences between the husband and wife, the worst sufferers are the children. There is a fight regarding the custody of the children. According to the personal laws of the party, as far as our Hindu law is concerned, till the age of 5 years, if they are males, the husband is entitled for maintenance. I'm sorry, custody. But as far as till the age of puberty, as far as the female children are concerned, the mother is entitled. But one important thing is in custody proceedings, what is important is the welfare of the minor, welfare and the upkeep of the minor, how the minor is to be maintained, they should be taken care of at all in all circumstances. That is the reason why Section 38 has been provided. Then under 39, appeals also have been provided. Within 90 days, you can file an appeal before the High Court if it is a family court, and before the High Court if it is from with 60 days if it is from any other court. Then, sir, power of transfer. Please remember, our acts are so made that they are mostly favorable to women. In the Hindu in the Hindu Marriage Act also, Section 19 is provided wherever the woman stays, she can file a proceeding where at the place where she stays within the jurisdiction of that court. As far as males are concerned, there is no such provision. But in the Special Marriage Act, it is said the question is the section 40 says even if the husband files a case before secondary court, let us say the wife stays in the wife stays in, let us say uh, let us say common, then in that case, yeah, the lady can always ask for transfer before the High Court if it is from intra-state, that is within the state, within the same state, if she can ask for transfer to the place where she resides. But if it is from one state to another state, the transfer petition has to be filed before the Supreme Court. And as far as the once the transfer, the question is all the documents on which you rely, you can file and they can be marked as exhibits. And once the appeal is filed before the High Court against an order of the family court or any other court, then the High Court can examine the entire gamut or the lower court order, and they have got the power either to set aside, cancel, confirm, modify, or vary the orders of the lower court. Then penalty, that is the other provision. The next one is 44. 44 is bigamy. What is the provision under which bigamy is punishable, sir? What is bigamy? Taking a second wife during the subsistence of the earlier marriage, and the person who commits such an offense is guilty of what is called bigamy. Who is a person who can maintain a criminal case for bigamy? It is the first wife who can file a case. But the Supreme Court, I think the 2 years back, they passed a judgment saying that bigamy is no longer an offense. So perhaps 44 may not be a valid ground today. Then penalty for giving false declaration. This is what is called, suppose in the marriage forms, when you get your marriage solemnized, you give a false declaration. There is no divorce proceedings at all. You have not been divorced by your previous husband, or you have not been divorced by your previous wife, and you give a declaration and sign the declaration, and such declaration is found to be false and a bogus one. Then in that case, you are punished for that, and imprisonment can be imposed. Then and whatever records are there, whatever documents are there, they are open for inspection by the parties at any time. Then transmission of copies of entries, and suppose let us say you want the copies to be given to you, you can apply for copies, and if there are any errors under section 49, you can also ask for correction of the errors. Please remember, most important thing is the importance is given to the Hindu Marriage Act, but the provisions of the Special Marriage Act is pure and simple. It consists of only 49 sections, but most of the sections are almost akin, similar, identical to the Hindu Marriage Act, except for the change of sections. It's something like the old Indian Penal Code, old Criminal Procedure Code, and the old Indian Evidence Act. Now you've got the BNS, then you've got the BNSS, and you've got the Bharatiya Sakshi Adhyam. That means that is the Indian Evidence Act. It is old wine in new bottle. Special Marriage Act, except barring certain provisions. The question is, it's almost similar to the Hindu Marriage Act, but the sections may be different and the procedure may be different. But all marriages solemnized under the Special Marriage Act has to be registered, whether it's under the Special Marriage Act or under the Hindu Marriage Act. Now, please remember, registration of a marriage is absolutely mandatory. And when you apply for a passport or when you apply for a visa, please remember, unless the passport and visa are there, you cannot take your wife to a foreign country. So this finishes the chapter on Special Marriage Act. Please remember, very, 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 very rarely we come across proceedings under the Special Marriage Act before the family court. To the best of my knowledge, most of the matters which are coming for divorce, judicial separation, restitution of conjugal rights are all under the Hindu Marriage Act, but not under the Special Marriage Act of 1954. And the aim and object of the Special Marriage Act of 1954 is to promote intercaste marriages, not to compel what is called change of religion, change of caste, change of denomination, and also to avoid social boycott, and also to avoid honor killings, and also to give a free liberty to the parties to choose their own better halves. And of course, the restrictions are there: prohibited relationship. You cannot marry. Your boy cannot marry before attaining the age of 21 years. As far as the girl is concerned, she cannot marry unless she has completed the age of 18 years. Why this restriction is imposed is so that they gain maturity, they can lead their lives happily, and they live their lives in cordiality, and so that there are no early births of children when the girl is not prepared to uh, follow the rituals of maternity, how to look after the children, and to see that the health of the girl is also maintained, and she is also well off, and she is also well educated. She can stand on her own legs. She need not depend on her husband for her maintenance, and the both of them live a life of cordiality and with each other, and the idea of marriage is completely fulfilled. That is the reason why the Special Marriage Act has been provided. You need not change your caste. You need not change your religion. You need not get converted. You need not change your denomination. And that is the reason it is advisable to get married under the Special Marriage Act. The rigors or the technicalities of Hindu Marriage Act is not found in the Special Marriage Act except under special circumstances. So this is as far as the Special Marriage Act of 1954 is concerned. Sorry, sir, today we were delayed because of our professional work. That is the reason. But at any cost, we didn't want to have discontinuity. We wanted to continue it at any cost. And that is the reason why we started late. I think my admin also must have informed you. I think tomorrow being a festival, I think my admin will inform you that tomorrow perhaps we may suspend.
No,
it.
no, no.
No suspension tomorrow, sir. But subject to adjustment of time, 10 or 15 minutes here and there. But the next topic which I will discuss is the Indian Divorce Act or the Christian Marriage Act. And after that, we go to the Hindu Law of Maintenance and Adoptions Act.
There is no suspension. There will not be any suspension of the class. Because today, sir, I seriously admire him because we are sat in the morning around for 11 o'clock. Work work was closed at 6 o'clock in the evening. He had a nap and then we got to go for lunch. That is what how it has been. That is what the late it was. Sorry for the delay. It is absolutely it was tight schedule today.
Any questions, please?
Any more questions you have? Please go ahead with the questions. Any questions you have? All right. Shall I conclude the class for today?
Tomorrow we discuss the Christian Marriage Act.
Tomorrow, Christian. Okay, unmute. Sorry. Madam, unmute. Yeah, you can unmute yourself and ask questions.
Any doubts, please?
Yes, sir.
చెప్పండి
సార్ సంతానం సార్
చెప్పండి బాబు
యువర్ ఓల్డ్ శిష్య 1990s
90s సార్ ఒప్పుకుంటానండి. వాట్స్ యువర్ గుడ్ నేమ్?
సత్యనారాయణ సార్.
ప్లీజ్ గో అహెడ్.
సార్ దిస్ వన్ ఇన్ mutual divorce,
yes,
what are the precautions? Both parties to be in one application or separately?
No, sir, separately it cannot be filed. The application should be in the joint names of the husband and wife, signed by both the parties, photographs of both the parties, and they should be represented by the same advocate, by different advocates also, but the party should be under your control.
Acha, if the boy can, that means boy advocate and girl advocate, boy advocate can file, both advocates can sign or what?
Both advocates can sign, absolutely, there's no problem, or a single advocate can sign, accept the wakalat on behalf of both of them.
But suppose two advocates also can.
There's no bar. There's no bar.
Mutual.
Then one more thing,
in
sir.
mutual consent, anybody can either.
It is better that there are two advocates, sir, so that the party. Listen.
Yeah,
the advocates may have control over their parties.
Yes, because one man means it will be single-sided. That's why both the advocates to sign means it will be.
In this
because
regard,
I seen some complications. That's why I'm asking.
Sir, in this regard,
and then second one is if an amount of some amount was they were expecting some amount as alimony or something, that can be paid before or after, sir.
That is to be paid after the decree. You can take time for payment of that money.
He did not pay before that.
Not necessary, sir.
So and if this amount is to be mentioned in the that is the joint application?
Sir, normally they don't mention, sir. What they do is bargaining takes place. And beral bertar anamata.
So,
And
after bargaining,
advocates welfare also is to be involved, isn't it, sir?
no, suppose if they demand some 10 lakh, shall we mention, say we are prepared to pay 10 lakhs as well, so it's so both
And I have
mutually
not,
agreed for
sir,
that.
Mr. Satyanarayan Rao, I have not seen any party paying it immediately, sir. Normally they pay for they take 2 or 3 adjournments to pay the money. After all, he is also to arrange money, isn't it, sir? Then
So that need not be mentioned, and we can take separately some this thing like payment and all.
Exactly, sir.
No.
Exactly. Sir, one episode I'll give you, sir, in the family court. What happened
Yes.
was a particular because I tell you the defect of Section 13 of the Family Courts Act, a particular lady was abusing her husband by calling him a bastard. Then the husband revolted and said, "If you are calling me that," then he called her by BITCH. Then what happened was both of them had exchanges. Then the judge was said, "Before you could call me names, you go on with your submissions." Then and the judge immediately laughed and said, "This is one of the occupational hazards of presiding over a family court." Then I told the judge, "Sir, these hazards of not allowing an advocate a direct entry into the family court and ask him to file an application under Section 13. At least an advocate can control the parties. But a court cannot control the parties. Why? Because the parties are not in the hands of the judge to listen. And no one wants to listen in a family court, sir. Women are equally violent. Men are also equally violent. You can conduct 10 cases, but you cannot conduct a single matrimonial case. That's my experience.
Yes. So you are 100% correct, sir. So the advocates are not allowed.
Normally, because advocates are not given direct, I'm not saying not allowed. They are not given direct entry. Only thing is, unless permission is granted by the court under Section 13 of the Family Courts Act.
Yes, sir. Yes, sir. Then one more thing, sir. Power of attorney on the side of the boy. The boy is saying in some outside the country, US or so.
Right.
And suppose that power of attorney is validated here in this district
it can be done. It can be done, but power of attorney cannot depose on behalf of the boy. The boy has to come and the evidence has to be recorded.
Sir, before that,
he can represent his son.
But filing and all, he can represent. Only for giving evidence.
Yeah, the party has to come.
Suppose if the judge asks anything, the power of attorney holder can
no, sir, he cannot. He cannot say anything. Only thing is he represents his son. That's all.
Then he can have a video call, and then if the judge wishes,
video conference can be arranged.
It's because he cannot come at some reason or other,
Exactly.
then he can talk. But the power of attorney is only to sign and present. That's all.
Power of attorney can only represent and represent the case. But as far as giving evidence is concerned, the party has to come. Or video conferencing.
Only representing means in what way, sir?
To say that he is representing his son is in United States or something, he is not able to come. I am looking after his interest. He will come as and when his evidence is to be recorded.
Yeah, he will come. Yes. Then he need not ask any other questions from
he can instruct the advocate how to do the cross-examination and all.
Yeah, of course. That is
as I'm enlightening you, something like that.
Yes, yes, sir. Sir. That's what. Any other precautions, sir?
No other precautions, sir.
Thank you, sir.
Welcome.
I am just listening like a boy in 1990s.
Yes, sir. Thank you.
Thank you.
Thank you so much, sir.
Right. Next.
Sir, Koteswara Garu.
Sir.
Sir, continuation to the same question.
Sir, 1 second, sir.
Just wait for a minute.
Nilesh Gar, wait change, sir.
Just
please,
yes,
Koteswara, go ahead, sir.
Sir, continuation to the same issue.
Yeah.
At the time of cross-examination of the girl, the boy need not be present, no, sir?
Not necessary, sir. It's not a criminal case.
Okay. Okay, sir. Thank you. So my question is,
because the girl will definitely know her husband. There is no question of not recognizing the husband. Not necessary.
Okay, sir.
All right, Venkat Garu.
Sir, I have one more question, sir.
Please, sir, one by one. I'll come back to you again. I'll come back to you again, sir. One question.
Venkat.
I'll come back to you once again. Please hold for you.
Okay.
Venkat Garu.
Good evening, sir.
Good evening.
Sir, unlike the same Hindu Marriage Act, the petition can be filed in family court or
No, same family court. If there's family court, if there is no family court, it can be filed before the principal senior judge of that particular place.
the same way in the Special Marriage Act as well?
Exactly, sir.
No,
Yes, sir.
not in.
No, if there's no family
district
court,
courts.
it can be filed in the principal senior court. District court has no jurisdiction.
Whereas with respect to guardian OP and all, it has to
Guardian
be
OP,
filed.
either the district court or the family court.
Okay, how about succession OP? sir?
Succession can be filed only, that is to receive debts, that is to receive money. You have to file it before the principal senior court. But as far as property is concerned, you have to pay half the market value as far as the claim is concerned, but file it in the same principal senior court. District court has no jurisdiction, sir. District court has got jurisdiction only regarding probate and letters of administration.
Thanks a lot, sir.
Thank you. Venkat Sachinan garu.
Hello.
Yes, tell me, sir. Good evening. Yeah.
Good evening, sir.
Yeah, good evening.
Sir, during the pendency of the suit, one of the 20 factors, sir.
Right.
Subsequently, the legal heirs of plaintiff were brought on to court in that not file a petition application to, as deemed as legal heir.
Yes.
But subsequently, after due to some other reason, that petition was dismissed by the court.
Right.
So, the legal heirs of the decision not brought on record. If you leave it as it is, what happens?
Sir, the provision for bringing LRs on record, if it is a plaintiff, it's Order 22, Rule 3. If it is a defendant, it's Order 22, Rule 4. But once the petition is filed, a regular inquiry is conducted. If the other side disputes it that you are not the legal heir, then in that case, regular
The application is dismissed.
dismiss, then you will have to go by appeal. You have to go by appeal or revision as the case may be.
But if you appeal, there is a delay. In the meantime, you have to proceed in the suit.
Not necessary, sir. You can say that you are taking further proceedings by challenging that order.
Okay.
A revision, not,
Even the plaintiff, on behalf of the plaintiff, after decree or the consent purpose, legally come on record.
no court dismisses an application to bring LRs on record unless there is a delay or there is an abatement.
There was a delay.
If there is a delay, then first and foremost is within 90 days you must file an application for bringing LRs on record. If you exhaust that 90 days, 60 days is given under Order 22, Rule 9 to set aside the abatement. That is legal death which has occurred. Even after that, you don't file it. Then Section 5 of the Limitation Act explaining each days of delay, you must file a petition under Section 5 to condone the delay.
Yeah.
No, normally no court dismisses it.
Non-appearance also.
Then if it is non-appearance, Order 6, Rule 4 is Order 9, Rule 4 is there. There is no limitation for Order 9, Rule 4. There you can file the application for restoration at any time.
All right, sir. Nilesh garu.
Okay, thank you, sir.
Welcome.
Nilesh.
Yes, sir. My question is that after mutual consent divorce, visiting rights will be given to the wife or not?
Visitation rights either to the wife or to the husband. Normally once a week or twice a week or once in the weekend or from morning till evening. And nowadays what the courts are doing is visitation rights. They are saying let the father come and see the boy in the court itself. A separate room is kept for that so that he can spend the time. Or during festivals, he can take the boy and give an undertaking that he'll drop the boy back to the mother on the next day or whatever it is. Visitation rights can be given to anyone.
Anyone.
Either the husband or the wife.
And also giving a permanent.
It is permanent till the pendency of the proceedings, sir.
Okay.
All right.
Thank you.
And Vasantrao garu.
Good evening, sir.
Good evening.
Sir, under the petition under God's and Wants Act, district court or family court actually?
Sir, normally they are filing it in the district court, sir. Even family courts can entertain. But unfortunately, what is happening is the family courts are saying we have no jurisdiction. Please remember,
Yeah,
if you see the act, the word family means includes guardian and wards also.
They are not entertaining in our
And
district.
that is the
That's
reason
why
file it before the district court to be on the safe side.
Oh, thanks.
Right.
All right, Mr. Venkat Garu.
One last. Sir, in case the respondent is a default in an MC,
Right.
and again a divorce petition is filed under family court.
Right.
So again, an interim maintenance can be.
He can ask, there is no bar at all.
So in that, okay, to execute that.
You execute that, you can always, there is no question of execution. You can take the copy, but all proceedings in the FCOP will be stayed till such time the amount is paid.
Okay, so again, the interim maintenance can be awarded in
Can be
FCOP.
awarded, sir, under section 24.
Okay, until the maintenance amount is paid, it will be.
Yeah, it will be stayed.
So for attachment, sir.
Attachment of whatever
property
remedies are open to you, can do. You can even ask for arrest also.
So that again, I need to file an EP, sir.
You can file an EP to execute that order.
The previous order, whichever
Whatever it is, that interim maintenance and expenses.
It's not since the FC the divorce petition in the family court is pending, so I will not have any.
Even if it's pending, there is no bar for you to execute that order under section 24 by any mode.
So under you mean to say interim maintenance or the maintenance which has
either
been
interim
awarded?
maintenance or legal expenses also you can recover.
Whichever it has been ordered under FC, sir.
Exactly, but you must file the certified copy when you file the EP.
Thank you, sir.
Right.
Thank you, sir.
Mr. Sriram Chandramurthy Garu.
Sir, if both the husband and wife are software engineers, the wife can file maintenance petition against her husband or not? That is
Sir,
my question.
there is no bar, but one thing is this: her earning or having earning capacity may be a bar as far as claiming maintenance.
But still she can file an MC.
Sir.
You have to create that, saying that she's in a. I mean, you know, do she have a child? Children?
Yes, she is having a child.
How many of them?
Only one female child.
Now put that in the front elevation and then talk.
And as a guardian of the child. Yeah.
Sir,
Okay,
you know how to make it, sir. I
husband-
don't need to tell you.
But Sriram Chandramurthy, shall I tell you one thing, sir? 1 minute.
Sir,
Shall I tell
you are on
you?
YouTube. You are on YouTube. Please remember that. You are on YouTube, sir. Sir, please call me, sir. I'll let you know, sir. Please call me on my number, Yogi. Please call
Okay,
me.
sir.
It should not be.
Okay.
I mean, it will be and again it will go to unnecessary.
Okay, sure.
Yogi,
891-964-0157. Please give me a call.
Yogi,
Okay, sir.
Yogi.
Yogi, sir. Please.
Yogi, thank you.
Sir, can I have your number?
9440.
Sir, please put me in the chat box, sir.
Okay, sir. Sure.
Yogi, sir.
Okay,
Sir.
thank you.
In a case, sir, the wife is deaf, dumb, and illiterate, sir.
Okay.
Hello?
Carry on.
We are hearing you.
Does the parents are permitted to give evidence on behalf of the wife, sir?
The question is
Are they
mental.
She is only dumb or deaf.
Both, sir. Both deaf, dumb,
Then
and
you need to give an
illiterate also.
appeal. Then you need to give the appeal saying that a special no people are there for this kind of dubbing things. She can give by name signs, gestures, signs, and it will be recorded.
Or physical disablement certificate can be filed. She can say my mother or father will give
No.
evidence.
Again, the gestures will change. They will add
But
on.
normally there are people who can also decipher the gestures. Nowadays in TV also you get classes where for deaf and dumb there are classes held by gestures. Or if she is educated, questions can be put to her and she can give it in writing also. There is no bar.
In case of illiterate, sir?
Illiterate, the question is
Again, it comes to different way.
illiterate అంటే ఆమె తెలిసిన లాంగ్వేజ్ లో అడగాల్సి వస్తుంది.
Okay, sir.
Sriram Chandramurthy Garu.
సార్
నెంబర్ చెప్పండి మీది.
సార్ 9440
9440
321 511
321
511.
511. ఒక్క నిమిషం. 9440 321 511.
ఎస్.
Got the call?
Yes, sir.
You will receive it.
Kalyan.
Yes.
Kalyan, thank
You'll give a call.
Thank
Sir.
you.
Christian Marriage Act
Thank
in India.
Tomorrow is the Christian Marriage Act
And Indian
and
rules.
Indian divorce. We'll come back to you tomorrow again. Thank you very much. See you tomorrow again. Namaste.